Today we're going to be talking about the O-1 visa. As you know, the O-1, there's two types. There's O-1A and O-1B. In this video, we're going to be talking about the differences between the two. We're going to be talking about qualifying factors and also filing tips from me. I've been doing O-1 visas for almost 10 years now. It was one of the first case categories that I worked on when I started in immigration law, so it holds a special place in my heart. Over the years, I've worked with some remarkable clients and learned so much about such a variety of fields. And so that's why I really enjoy working on this case type. A lot of my clients always are very humble and they always shy away from saying, oh, I'm not extraordinary. I could never apply for O-1. And I'm like, you'd be surprised actually. So first, starting with the O-1A. The O-1A is for individuals with extraordinary achievement in science, business, or any other field really. There's 8 categories. And if you notice, these 8 categories are very similar to the EB-1A category. So a lot of times when you have an O-1A client, their main goal or their end goal is to apply for an EB-1A, which makes sense because there is a lot of transfer between the two. There's showing that you have awards, showing that you have membership, being a judge, publications about yourself, you played a critical or leading role, high salary, original contribution of significance or widespread impact. I would recommend this for anyone who's had several years in the field. If you're coming from the science background, a lot of my clients are in research or they have some extraordinary achievement that they want to use to prove that they had an original contribution. So it could be through patents, it can be through like scholarly articles. So, and remember, there's no set number of how many articles you need to have, but you should have a lot relative to your field. And we always want to look at impact factor because it's not enough just knowing that it was published in a journal. We want to show that the journal was distinguished, and we also want to show that there are a lot of citations. So if you can show that you had this really great article that was cited by all these different researchers, different peers, right, extraordinary in their field as well, that will definitely help your case. So if you have a lot of scholarly articles, if you've also served as an editor, so usually when you're expert in the field, you get asked by journals to review articles, to make edits, to decide whether or not the journal should even accept the article. So if you have proof of that, we can use that for the judging category. We can be flexible. I've used it with comparable evidence. So for example, I've used it for an individual who had he didn't review scholarly articles for a journal, but he reviewed proposals within his organization for patent, for example. Or sometimes they have like committees, right, in the workplace. Maybe you work on a committee and you're reviewing proposals for budget. We use that. Or maybe you are a professor, but you're hired by the government to review legislation or budget proposals. We can also use that in the judging criteria. So it's not limited just to a narrow interpretation. Another common category that's used for the O-1A is leading and critical roles. So let's say you work for an organization, whether it's on your OPT or maybe you worked on H-1B. If you can show that you played a leading role, or if not a leading role, then a critical role, right, for this distinguished organization, you can use that evidence to show one of the prongs. One of the pitfalls for a critical and leading role is that you want to get the letter from as high up as possible. So if there's an executive of the field or the lead principal researcher, getting the letter from that individual might be better than getting it right from like the supervisor right above you or getting it from a peer. Other evidences that you can submit for the leading critical role could be organization charts, maybe your salaries to show that it's high, and getting letters, right, explaining what your critical role was or what your leading role was and why it was so important to this company. And you also want to gather evidence showing that this company is distinguished. Other categories you can maybe go for is membership. If you're a member of a distinguished association where it requires outstanding achievements of its members, then you can use that to show, yes, I am extraordinary. And remember, these memberships are not excluded just to US-based organizations. It can also be foreign organizations. So I have clients saying, hey, I'm not a member here in the US, but I'm a member back in my home country. Does that count? Yeah, as long as we can show the criteria that they do require outstanding achievement in the field, then you can definitely use that as proof. And high salary sometimes is used for O-1A applications if you can prove that your salary is of the 90th percentile, right, of whatever field you're in. And that doesn't have to be, again, limited to the US. Even if your salary might be low compared to the US, if you can prove that it's high in your home country, you can use that as evidence as well. And then original contribution. I've seen that a lot usually with like business applications. Let's say you're an entrepreneur, you're showing how your invention made a widespread impact in the field. Make sure you get letters from experts in the field proving that, getting objective evidence. The RFE point that I see the most for original contribution is that these are just, allegations. These are just charges made by the attorney or by the individual, but they want more objective evidence, right? So if you can get newspaper articles, if you can get press, if you can get a business plan, if you can get anything else to show that this had widespread impact. So for example, I had a case for an athlete who used a specific technique in training, and by using this training technique, his students ended up winning the gold medal at an international competition. So I'm asking for articles where he published his unique technique. I'm getting pictures, I'm getting testimonials from the student athletes who used this technique, and then proof that they did well in the competition is directly tied to the technique that this coach used, for example. So you could do it that way, or you can also use patents, right? So a patent is a really good way. It's original. It's one of its kind, and then with a patent showing how it's been widely used. And remember, for the O-1A, you do need to get a consultation letter. The consultation letter is to say, one, that they're extraordinary, so they're reviewing your qualifications, and then two, saying that they have no objection to you being in the field. Usually for the O-1A applicants, it's really hard for them to find a managing or a peer or a labor union for their field. So most of the times we reach out to an independent expert to write a letter saying they have no objection to this individual working in the US, that person truly is extraordinary. You can use someone in the field that you know, or you can reach out to an organization. For example, if I'm an electrical engineer, maybe I reach out to IEEE and see if they're willing to write a letter. You can also find another expert, right, in the field, as long as you could prove their credentials. Or you can even reach out to a third-party organization that does expert opinion letters, and that expert can also write an advisory opinion letter for you. So there's different ways to tackle that. Now, jumping to O-1B, this is for distinction in the arts or for individuals who may be working in motion pictures or television industry. The distinction level is actually lower, so it doesn't have to be as extraordinary, top 1% in the field. As long as you have distinction in the field, you can get approved for the O-1B. The O-1B, like I said, two different fields, arts and then also motion picture and television producers. So the reason why there's two different is because the motion picture and television industry is highly unionized and highly regulated. So you have to go to the right consulting or the right management organization or the right guild to make sure you get a letter from them saying that, one, you're extraordinary, but again, they do not object to you working in the field because it's highly competitive and highly regulated. For the arts, it includes everything from studio art, animation, screenwriters, musicians, graphic designers, you name it. Anything related to the arts can apply for the O-1B. So the criteria for the O-1B, first one is showing that you are a star or leading participant of a distinguished production or event. You can prove that your production or organization is distinguished by, there's a number of ways. You can show prestige in the industry. So if you have any rankings, I've done that before where I'm like, this is the top 10 animation studio in the country, and there's usually like rankings that you can use. You can get newspaper articles referring to your organization as prestigious or one of the best in the field. You can also show alumni, right? So we've had, from our studio, we've produced these movies, and that's why we're distinguished. We've had these directors work with our studio, so we're distinguished. So you're kind of looking at the achievements of the organization as a whole. And then the second one is to show that you have, significant recognition, or you have press about you, right? So it's whether through newspapers or whether it's covered in different media or international, that works as well. Third one is to show that you're a star leading participant in a distinguished organization. So it's related to the first one, but now you're showing that you're playing a leading role for the organization as opposed to the production or the event. Another is to show that you have commercial success. So showing ticket sales, box office sales, television ratings, showing that you're the reason why you drew this large audience. Another one is to show that you have recognition from experts in the field, right? So you can get letters from people in the field. You can show, again, press about you, press releases from government agencies showing that you are really top of the field. And then the last one is high salary. So if you command a high salary in this industry, and for arts, it's really hard. So if you have a high salary, that does actually show that you're in high demand and that you are extraordinary in the field. Some of the tips that I would say for the O-1B is make sure you find out for the advisory and the consultation letter, make sure you find the appropriate guild, reach out to them early in advance so you see what is required. As opposed to the O-1A, the O-1B, The advisory opinion letters, usually you have to submit the forms, you have to submit the contracts, you have to submit itineraries in advance. So I recommend doing it at the end, right before you file the case, because that's when everything is done anyways. And it's almost like submitting a copy of your packet to the organization for review. A lot of the organizations have page limits. They want specific documents, so make sure you follow the directions. There's usually a fee, so make sure you watch out for that as well. And there's a turnaround time. So make sure you give yourself enough time so that you can get your advisory opinion letter before you file with USCIS. Also, for the O-1B, you can hire an agent, or an agent can sponsor your case. So you can create your own company that can act as your employer and as your agent, or just as your agent, or you can have an individual to act as your agent. And why we typically see that is because usually for artists, you're working on short-term projects, right? So it's not like if you have let's say you have a case with Mocha, they're not going to hire you as an in-house, let's say, designer. They're hiring you for, let's say, this exhibition. So for the duration of the exhibition, they want to hire in for your services. It might not even be full-time. It might be part-time for a specific role. If you have an agent, then you can get hired through your agent with Mocha. You can be on payroll with the agent, and the museum hires you through your agent, or the museum can hire you directly and have you on payroll, or have you as a contractor, and the agent is just facilitating the employment negotiations. And so you just have to make it very clear, right? What type of contract is it? What kind of relationship is it? And make sure you have everything in writing. Even if it's an oral contract, you want to have it written in writings to summarize the terms of employment, or the terms of agreement between you and your agent, and also with this third-party employer. And also something that's really important for O-1B is to have contracts or letters of intent. So saying, I intend to hire this artist as soon as he or she gets approved for the O-1 in this capacity from this date to this day for this exhibition. So having these letters of intent show that, yes, you are in high demand, right? Because if you're saying, yes, I'm going to just have this agent sponsor me, well, how's USCIS going to know if you're going to have work for 3 years? This agent might not be able to find work for you. That's not going to work. So you want to show that there's some work lined up for you already. And you also want to submit an itinerary. Now, I always get questions, how am I going to do this itinerary for 3 years? I don't even know what I'm going to do next month. Well, it's an itinerary, so make sure it's far out, but you're not going to be held to it to a T. USCIS understands that there might be some changes. As long as there's no material changes, it's okay. So that's why if you know that you're every year you perform at this venue for this concert, every year you go to this competition, every year you do XYZ. Some of these annual events are really nice to put on itinerary because you might not know exact dates, but you know every summer or every March, I usually do this type of event or this kind of orchestra or this kind of exhibition. Then you definitely want to put that on your itinerary. And that's why you want to get started early in the process so you network and you have gigs lined up for you. Because that itinerary is very important. If you're not able to show you have 3 years, even if your O-1 is approved, it might only be approved for 1 year or 2 years. So if you want to get the maximum 3 years, it's really important you do that. Well, that's it for today's video. Hope you found it helpful and that you learned a lot about the O-1A category. And if you have specific questions about your case type or about your background, please feel free to reach out. I'd be more than happy to speak with you. Thank you.